everyone. And let me just take the
Afternoon, sir.
attendance.
20 रहेगा तो 5 पे ठीक है. हाँ तो 20 into 5
Yes, Chaudhary.
10 कितना हुआ? हाँ
10 पर कीजिए है ना 20 का 0 लगाओ.
Yeah. So in the class now is Astha Khandelwal, Aditya, Ashutosh Marshi, Asmit, Ayush Bothra, Ritik Bhardwaj, Ishpreet Singh, Jamima, Karan Agarwal, Naman Jalan, Naveen, Navya, Preetam, Sambhav Garg, Saurabh Garg, Saurabh Yadav, Shreya, Tushar, Vanshika, Vatsal Rastogi, and Yashvardhan Tiwari. I hope I have not missed anyone. Don't raise your hand unnecessarily. Jhanvi Singh, Ashutosh, Ritik, Jamima, Navya, Sarvansh, Arpan. Come to the class on time, and otherwise you have to raise the hand like this. Fine. Okay. So let us just proceed further with the what we have studied in the last class itself. Okay, so we have studied about the formation of the company, and now today we will be going with the memorandum of association, articles of association. So there were some slides regarding memorandum and articles of association over here in this slide also. I told you that we will be discussing it in the next class. So memorandum and articles of association, these are the two important documents which are to be prepared, whereas memorandum tells you the limits beyond which a country cannot go, a company cannot go, and the articles of association actually tells you about the rules and regulations which is to be followed by the company in order to execute the objectives of the company which are given in the articles of association. So both the documents are interrelated to each other. So memorandum of association is a charter of the company. It is said to be a charter of the company. It is a document which, amongst other things, defines the area within which the company can operate, or you can say it actually determines the scope of the company. It actually determines the limit in which the company will be doing. Means a company which is established for certain purpose should do only that purpose. It should not actually do something else. So this particular document ensures that the company is doing for what it is established for. So first step in the formation of company is to prepare a document called memorandum of association. In fact, memorandum is the one of the most essential prerequisite for incorporating any form of company under the Act. So as per section 256, memorandum means a memorandum of association of a company as originally framed or as altered from time to time in pursuance of any previous company law or of this act. Okay, so memorandum is something which has been framed either initially, or you can even change the memorandum from time to time as per the need and requirement of the time and the company itself. Suppose my company has been established as a company of textile spinning mills like Reliance Industries Limited. It was initially established as in spinning mills. Now it wants to diversify itself, and it wants to enter into petroleum sector. It wants to enter into the telecom sector. So accordingly, either they have the two options: either to form another company for doing this, or to just change the memorandum of association to include one another clause which actually the purpose of the company itself. So in that way they have to change the memorandum of association. So memorandum which is either initially prepared or altered from time to time. So whatsoever is the memorandum of the company as on that date will be considered as a memorandum of the company for any of the things after that. Means it has to incorporate all the latest amendments which the company might have undertaken or might have gone with in the recent time period. Okay, so preparation of memorandum and articles further. Section 4 of the Act prescribes that the particulars to be mentioned in the memorandum of association and other requirements is the constitution documents of the company. The company cannot depart from the provisions of the memorandum. If it enters into a contract or engages in any trade or business which is beyond the powers conferred on it by the memorandum, such contract or act will be ultra vires, or you can say will be void. So actually, I have already told you it determines the scope of the company, and further also it actually, you can say, what it does is that it actually powers the company. It gives the powers, it empowers the company to enter into a contract which is given under the memorandum, or if it goes beyond that, it will be void. So section 4(6) of the Companies Act 2013 provides that memorandum of association should be in one of the forms which is specified in table A, B, C or D of schedule 1 to the Act, as may be applicable in relation to the type of the company proposed to be incorporated. So for a public limited company, it is a type C, which is you can say the table C. The memorandum given in the table C is to be taken care of. So what I want you is to have to just go on Google and search for these memorandums, and you may find it, and you just need to just go through this memorandum, that what type of memorandum is used for what type of companies to be incorporated. Okay, so as per section 4(1) of the memorandum of the limited company must contain the following: it must have name clause, situation clause, object clause, liability clause, capital clause, and clause F in case of a one-person company, that is a subscription clause, that in case of the death of the subscriber, who will be the nominee. So in that case, he has to additionally give this. Otherwise, these 5 clauses have to be there in every company, along with the association clause, which is also at the back, which comprise of that who are the directors who have signed or subscribed to the memorandum of the company at the time of its incorporation. So the above clauses are compulsory and designated as a condition prescribed by the act on the basis of which the company is incorporated. Okay. Further, let us just go in detail. Name clause. A company being a legal entity must have a name of its own to establish its separate entity. The name of the company is symbol of its independent corporate existence. The first clause in the memorandum of association of the company states the name by which the company is to be known. The company may adopt any suitable name provided it is not undesirable. So the first most step which we have studied in the formation of the company is to just have the name. So for having the name, what is to be done? You have to search the name for the name availability, and it should not be misleading. It should not be such that it is having something which is against the law, and it has to be within the law itself. So accordingly, the names are to be taken by the company which are allowed, which for which the there is allowance. So once the name is desired, is it decided, it will go in the process of the company, as in your articles also, as in your this memorandum also, and you will apply by the same name to the registrar of the companies for the registration of the company. So in case of one-man company, the words OPC or one-man company shall be mentioned in the brackets below the name of such company, wherever the name is printed or affixed or engraved. Ministry of Corporate Affairs (MC) has clarified that display of its name in English in addition to the display of the local language will be sufficient compliance with the requirement of this section. Means wherever the name is to be mentioned, it has to be
Excuse
mentioned
me,
either
sir.
in the local language or also in the language in English. Yeah, any doubt up till here?
Excuse me, sir.
Yeah, please.
Sir, actually, I was a bit late because of network issue, so you didn't put my attendance, I guess.
Who is this?
Sir, Priyanshi Sharma.
Okay, Priyansh, fine. Don't worry, attendance is being taken care of. I will take it in at the end again. So while you will be there in the end, you will be marked. Don't worry about it. So stay till end. Don't
Okay, sir.
yeah, go in between. Fine. So next is the situation. I hope the things are clear about the name clause to everyone. Rianshi, are you clear about the things in the name clause?
Sir, I just joined just now.
You have just joined.
Yes, sir, I joined in the beginning, but due to some network issue, it disconnected.
Okay. So anyone from the class, are you clear about this name clause? Should I proceed further?
Yes, sir.
Yeah. Any doubt?
No, sir.
Fine.
No, sir.
Okay. So next is your situation clause. The name of the state in which the registered office of the company will be situated must be given in the memorandum, and that what is the situation clause. But the exact address of the registered office is not required to be stated therein. Means while you are filing the application for your registration, at that time it is not required, but within 15 days of the incorporation of the company, it must have a registered office to which all the communication and notices may be sent. So the company must also furnish to the registrar verification of its registered office within a period of 30 days of its incorporation in such a manner as may be prescribed. So within 15 days you have to tell, and within 30 days you have to get it verified, and that verification has to be done by the registrar office, and that is to be done. So situation clause actually tells you the address of the company where the company is situated. Why situation clause is necessary? Because it decides the jurisdiction of the company, in which state the company's office will be, and accordingly the registrar of the company who is having jurisdiction in that state will take the cognizance of the person who is of the company which is accordingly situated or which is accordingly located. So this actually tells you the address and the state in which the registrar office of the company will be there, and it is to be informed within 15 days, and compliance has to be done regarding the verification of the same in 30 days of the incorporation of the company. Now, third thing is most important is the object clause. So now the third compulsory clause in the memorandum sets out the objects for which the company has been formed. Now, why have you formed the company? This is so we have normally the company is formed in order to do business. So here you have to mention that what type of business the company will be involved in. So under section 413 of the Companies Act 2013, all the companies must state in their memorandum the objects for which the company is proposed to be incorporated and any other matter considered necessary in the furtherance of those objects. Okay, so anything which is required in order to fulfill those objects should also come here if it is substantially not at all covered in the main object of the company itself. Next is your liability clause. The fourth compulsory clause must state the liability of the members is limited if it is intended that the company is limited by shares uh, or limited by guarantee. So whatsoever is the liability of the company, whether it is company limited by shares, whether it's a company limited by guarantee, whatsoever it may be, it has to be mentioned. Okay, the effect of this clause is that the company limited by shares, no member can be called upon to pay more than what remains unpaid on the shares held by them, and in case if the company is limited by guarantee, nobody will be compelled to uh, you know provide more than what he has given a guarantee of at the time of incorporation or at the time when he has been entered as a member of the company. So this is a very important clause which determines the liability to what extent the company's member will be held responsible or liable in case if it is needed. Next is your capital clause. So this is the fifth compulsory clause which must state the amount of capital with which the company is registered, unless the company is having unlimited liability company. So if the company is unlimited, having unlimited liability, then there is no need for amount because it will be liability, the liability will be unlimited. But in this case, the company has to be, this is actually the authorized capital of the company. You might be have studied this authorized capital in your corporate accounting. So this actually tells you what is the authorized capital of the company and into which the company shares must be divided. That is a fixed value, which is commonly known as a nominal value or registered value or authorized value. So this capital clause actually tells you that the company is having this much of authorized capital, and this is the limit to which the company can issue its shares, or this is the limit to which the public can subscribe for it. Right. So next is your declaration of subscription. The subscribers to the memorandum declare that we, the several persons whose name, blah blah name and blah blah address and all that subscribed below are desirous of being formed into a company in pursuance of the memorandum of association, and we respectively agree to take the number of shares in the capital of the company set opposite to our respective names. So the name just opposite to the names, the number of shares which is to be taken by the company are also mentioned, and then follow the names and addresses, description, occupation and subscribers, and the number of shares each subscriber has agreed to take, and their signature as attested by the witness. So accordingly, that's why I'm telling you to just download. You have to do this. Download the this table A, table B, table C, and table E. These you have to download and observe the memorandum, the format of the memorandum of association, which is prescribed by the Companies Act. It is actually given under the Companies Incorporation Rules 2013. So you can even go for this INC 13. Okay, so this is where it is required, particularly for this declaration of subscription. The statutory requirement regarding subscription of memorandum are that each subscriber must take at least one share. So a person who is actually want to be a member of the company which is limited by shares has to take at least one share. Each subscriber must write opposite to his name the number of shares which he is taken, or which he agrees to take, that you have to write it opposite to it. Okay, so these are the requirements further. I hope there is no problem in your this memorandum of association of the company. Have you understood all the clauses properly? Or do you need any clarification? Any more clarification is needed, then you please tell me. Should I proceed?
Yes,
Come on.
sir.
Shreya, you have to tell all
Yes.
this.
No, sir, no clarification. It's clear.
Fine?
Yes, sir.
Okay. So according to now, as we have the memorandum of association of the company, in the same way there is one more document which is called articles of association of the company. So according to section 25 of the Companies Act 2013, articles means the articles of association of a company as originally framed or altered from time to time or applied in pursuance of any previous company law or this act. This definition is similar as that of the memorandum. It also means that as on today, if I will see as on today, the articles which will be applicable to my company will be including all those changes which has happened till yesterday. Okay, so all the changes of the articles which are required to be made till yesterday will all be included over here as a, you can say, as a article. So articles of the company shall be in respective forms. Now up to A, B, C, D, E, you have memorandum of association. So F, G, H, I, J in schedule 1 may be applicable, will be applicable to the articles of association. So you have to just see the mock articles of association of the company also, and you have to just find out that what are the differences in the various type of companies for all these schedules for A, B, C, D, E and F, G, H, I, J separately. Okay, so this is one of the assignment which you have to do, in which you will know practically how these documents look like and what are the things in these documents. And I'm expecting some questions also from you, if you can, if you want to ask that what actually carries a difference and how are they actually differ from each other or something like that. If you want to ask, if you have any confusion, if you can't understand any language of this, you can ask it in the class. So in the next class, that is tomorrow, we will just take this up. Okay, next is entrenchment provisions. So articles may contain provisions for entrenchment to the effect that specify the provisions of the articles may be altered only if the conditions and procedures that are more restrictive than those applicable in the case of special resolution are met or complied with. So it says that articles can be altered, no problem, but it has to be altered in a systematic way. The change in the articles of association has also to be prescribed and specified that how the company will be able to change its articles and procedures, which in case it will be requiring a special resolution, all this has to be met. So any condition procedures that are more restrictive than those applicable in case of special resolution have to be there, and they have to be complied with in order to change the make the changes in the articles. So the Companies Act 2013 recognizes an interesting concept of entrenchment. This was not before. Okay, this has been introduced only in case of only from 2013 to this Companies Act 2013. So essentially, the entrenchment provisions allow for certain clauses in the articles to be amended upon satisfaction of their conditions or restrictions, such as obtaining 100% consent. Means there will be certain restriction on certain articles of the company which will be requiring 100% consent of all the members of the company, then only it can be changed, those prescribed in the act. So these provisions act as a protection to the minority. Sometimes what happens that because company is something which is run through majority itself. So here there is a protection to the minority which has already been given under this act. It ensures that there are certain articles, the important articles of the company, which cannot be changed, which cannot be altered until and unless there is 100% consent of all the members of the company, then only the articles will be changed. So this actually provides a protection to the minority shareholders also, and if 100% is not there, there will be no change at all. Okay, so this will empower the enforcement of a pre-agreed rights and provide a greater certainty to investors, especially in the joint venture. So this is something which is a very good step taken up in 2013 for protection of the minority. Otherwise, what happens? A person who has invested in the company, he feels actually deceived. He feels actually, as something wrong has happened to him. So this should not be there. So in order to protect that, this clause has been the clause of entrenchment has also been introduced. This is about your article. So you can see what are the contents of the articles of the association of a company, and we will discuss it tomorrow. What are the contents you have studied, and I may ask some of you to share your screen. Okay, so please be ready with the things, and so that I will be able to see it. Shreya, you have to do it compulsorily.
Yes, sir.
Yeah, you have to. I want you to download all the articles and all the memorandum of association of the company and find out the difference between these two. You and Jamima, both of you have to do. Jamima can take the articles and you can take the memorandum. The difference
Oh,
between all the schedules of the memorandum, and I want you to just display it in the class tomorrow. I will give you the access to it. I hope you already have the
oh,
access to share your screen, because I have made you the owner of this particular thing also. Okay.
okay, sir.
Yeah. If you face any problem, please tell me. Next,
Okay.
we have already done this because this was one thing which we have studied over there in your uh, yeah. Now, how to alter the alteration and memorandum of association articulation, how it can be done. So section 13(1) of the Companies Act 2013 provides that save as provided in section 61 dealing with the power of limited company to alter its share capital, company may by a special resolution and after complying with the procedure specified in this section can alter the provisions of its memorandum. So as I've already told you that change in the memorandum is the change of the maybe the need of the time. So as per time, you need to change the memorandum of association because this actually determines the scope of the working of the company. So if you do not change this and you do certain things which are which otherwise your memorandum doesn't allows, then it will be ultra virus. It means that the directors have gone beyond the limits and it will be void, and this will make all the directors held personally and responsible. So it will be, so this will be one of the clause of lifting and piercing the corporate will, because the directors are going beyond their powers. Okay, so memorandum of association of company may be altered in the following respect: by changing its name. For example, you want to change the name of the company, by altering it in regard the state in which registered office is mentioned, or by altering the objects of the company. You want to change the objects of the company. Okay, share capital also you need, because sometimes what happens, the authorized capital which you have decided, suppose 10 lakh was the authorized capital which you have decided and you have registered your company with that. Now the company is exhausted with issuing all the shares up to 10 lakhs. Now it has to increase its authorized capital. So such authorized capital needs a alteration in the memorandum first, and then only you can go for change in the authorized capital. So suppose, for example, in this case, this in this point B, you want to change your state from one state to another. You want to migrate, like this Tata Nano also migrated. First, it was registered with the this West Bengal, and then afterwards it came to Gujarat. So this migration happens only when you are able to change your memorandum of association, because this is a public document which actually tells that what company can do, what company cannot do, what are the objects of the company, what is the capital of the company. So it is equally binding for the other parties who are entering into a contract with the company. So these all changes must be here in order to proceed further. In the same way, if there is a reorganization in the capital, so some designate some you have changed some of the shares, you can say the nominal capital of the shares from, suppose from rupees 10 share you want to make rupees 100 shares with the same capital. So in that way it will need some alteration. You can also reduce the capital if you have some extra capital, so that reduction can also be done with the help of the alteration in memorandum of association. Okay, so the provisions or conditions of the memorandum of association relating to the name clause, registered office clause, object clause, liability clause, subscribe, these all are related to what? These all are related to these clause only. Okay, first is the name clause, second is situation clause, third is object clause, fourth is your capital clause of the company, right? So likewise you can just go for it. So the provisions or the conditions of the memorandum of association relating to the name clause, registered office, object clause, limited liability clause, subscriber clause as provided in section 4 of the Companies Act, or any other specific provisions contained therein can be altered by following the prescribed procedure laid down in the Act. So, and further strict compliance of the prescribed procedure is demanded by the law, because you are changing what? You are changing the principal document of the company. And if you do not change it according to the prescribed procedure, then there will be a problem. So failure to comply with express provisions made under the Act for the purpose of alteration of the provisions of the conditions contained in the memorandum will be deemed to be nullity, as if your memorandum has not been changed. So if you try to change something which actually requires a lot of efforts to change, and if you do not put the efforts, the things will remain intact. So the law has also given this, that if you are not at all following the things in the way it should be followed, it will just treat as if it has not been changed. So the original document is the original, because the document before changes will be still be applicable, and the changes will be deemed to be null. Okay. Further, sections 13(6) provides that a company shall, in relation to any alteration of its memorandum, file with the registrar a special resolution passed by the company. So what is to be done? Then the company has to pass a special resolution, and the copy of the resolution signed by the appropriate people must be filed with the registrar of companies that we have resolved to change it. Now section 1310 provides that no alteration made under this section shall have any effect until it has been registered in accordance with the provisions of the said Act. So the resolution which you have given to the ROC along with the proper form, duly filed and signed, electronically signed, you have to file the form, and then only, unless it is registered, you cannot take the action for that particular changes which you are proposing. So it has to be provision under the provisions of the Act, and it should be properly registered. Until unless it is registered, the changes are registered, it will not be applicable. So further, any alteration to memorandum in case of a company limited by guarantee and not having a share capital, purporting to give any person a right to participate in divisible profits of the company otherwise then a member shall be void. Now this is one of the very important thing, that a person who whom a company has given a right to be to participate in the divisible profits of the company, okay, And that too, if that person is not either the subscriber and he has not even given a guarantee, so such type of thing is not allowed at all. So any alteration in the memorandum in such case will not be allowed. Okay. Next is registration of alteration. So section 13(6) provides that a company shall, in relation to any alteration of its memorandum, file with the registrar. Now what is to be filed? The special resolution passed by the company, as I've already told you. The approval of central government if the alteration involves any change in the name of the company. If you are changing the name of the company, once you have fixed it, then you will be needing the approval of the central government in this regard. So that approval has to be filed. So the special resolution shall be filed with the registrar within 30 days of passing the resolution in the prescribed manner, and payment of the prescribed fee with the time specified under section 403. So you have to comply with it. As per section 39, registrar shall register any alteration of the memorandum with respect to the objects of the company and certify the registration within a period of 30 days from filing the special resolution. So there is a last date for registrar also, that they have to fulfill this requirement within 30 days of filing. So the time period for filing is whenever you have taken the resolution, within 30 days you have to file it, and after your filing within 30 days, the registrar will also give the clearance whether accepted or not. So this was all about your alteration in the memorandum of association. Next is alteration in the articles of association. A company has a statutory right to alter its articles of association, but the power to alter its subject is subject to the provisions of the act to the conditions contained in the memorandum. Now, what is the principal document? Principal document is memorandum of association. It actually governs, or it actually you can say determines the articles of association of the company. So articles of association are the rules framed by the company, which have to serve the purpose which is given under the memorandum. So memorandum defines the scope and articles actually executes it. Okay, so subsidiary company do not hold shares in its holding company. Section number 19 provides that no company shall either by itself or through its nominee hold any shares in its holding company, and no holding company shall allot or transfer its shares to any subsidiary company. Any such allotment or transfer of shares of a company to its subsidiary company shall be void. Okay, so this is something which is related to this. So this regarding this particular clause, we will talk about when we will be talking about the types of the companies, which is your next chapter. Okay. So next, however, this will not apply in the following cases where the subsidiary company holds such shares as a legal representative of deceased member of the holding company, where the subsidiary company holds shares as a trustee, or where the subsidiary company is a shareholder even before it became a subsidiary company of the holding company. So this is further provided as subsidiary company referred to above shall have a right to vote at the meeting of the holding company only in respect of shares held by its legal representative and the trustees. In case of a holding company which is a company limited by guarantee or unlimited company not having share capital, the reference of the share shall be constructed as a reference to the interest of its members wherever it is, in whatever form the interest is. Okay. So next is your service of the documents. I hope you are able to understand this, except this subsidiary company. I hope the things are clear to you. Any clarification needed, please tell me. Anyone, any question? If you want to raise, if you are having any, please tell. Okay, so let me just take you to your syllabus also, where we stand and what we have done till now and what is remaining. So there are certain more things are there, like doctrine of ultravirus and all, which we will be discussing maybe tomorrow or so, along with this memorandum and articles. It comes under this chapter itself, so that will also be I hope it's opening. Don't think. It's working slow. Sometimes there is a technical glitch which has just happened on the system also. Yeah. Hope you are able to see this, your course handout, everyone.
No, sir.
No, sir.
अभी दिख रहा है नहीं दिख रहा है?
Sir,
No,
only the
sir.
folder
No,
is visible.
sir.
Sir.
No? Okay. Let me just share it from there then. अभी दिख रहा है?
Yes, sir.
Yes, sir.
So here we are. So we have completed up to here. Okay. We have completed all the things up to here. And today was our 7th session, I suppose. We had to start this, but I'm over here now. So in the next session, I will take both of these, because in this most of the things you know very well. You know about shares, debentures, and all that. So I will just quickly take both of these things in the next session itself. So the type of companies and the capital and the financing of the companies, along with some memorandum of and this changes in the memorandum also. Okay, so this is what is which we will be doing tomorrow. Okay, so up till here we have already completed. So slowly we will proceed further and we'll do the things tomorrow and onwards. Okay, so any question for or anything you would like to share or ask me, or any query you have regarding assignments or so, you can tell. And I'm planning to have one of your quiz also. So soon we will be having that too. Maybe in the next week, in this week itself. Okay, whatever I have taught you. Yeah, so one thing I was proposing, if you can have this class which we are having, means if we can finish off with the classes on Wednesday itself, and that too before the lunch. So I have requested Shreya to find out certain slots which will be applicable and agreeable to all of you. All of you means it has to be passed with a special resolution, means you must all agree with that, so that you will also get free early and I will also get free early. So if it can be done, then nothing better than that. So Shreya, I would request you to
Yes,
just
sir.
see the slot and ask it on our group, which is our official group of
O-
our class, to the
Okay,
students. If
sir.
they agree with it, they will say it, and accordingly write an email to me. I will get the timetable change.
Okay, sir.
Right. So I would prefer to have something in the morning so that we can study consistently, and that too within this uh, the this Thursday. Don't go on Friday.
O-
Okay.
okay, sir.
So thank you for that, and let me take the attendance now. Asta Khandelwal, Abhigyan
Present.
Gupta, Aditya, Anshul
Present,
Goswami,
sir.
Arpan Mishra, Ashutosh Maharshi, Ashmit,
Present, sir.
Ayush Bothra, Ritik Bharadwaj, Ishpreet, Janvi Singh, Jamima, Karan Agarwal, Lakshya,
Present, sir.
Aman, Naveen, Navya
Present,
Singh,
sir.
Neha Singh Rathore,
Present, sir.
Pritham, Priyanshi, Raghav Dubey, Sambhav Garg, Sarvansh Sinha,
Present,
Saurabh
sir.
Yadav, Shahid Chauhan,
Present,
Sara
sir.
Khan, Shreya Dharan, Shubham Singh Rana, Tushar Khandelwal, Vanshika Sunil, Vatsal Rastogi, Yash Chaudhary, and Yashwardhan Tiwari.
Present, sir.
Thank you all for being over here and coming to the class regularly. And let's meet tomorrow. Fine. Okay. Have a nice day, all
Okay,
of you.
sir.
Bye.
Thank you, sir. Have a nice day,
Thank you,
sir.
Sir,
sir.
have a nice day.
Bye,
Thank you,
sir.
sir.
Bye. Bye. Bye.
Bye, sir.